All right, so again, good morning, everyone. I'm Governor Garland Gilchrist, and I'm co-chair of the Chief Justice Cormac, and we're going to do something a little better than we did in the first meeting. We're going to take attendance in the beginning. So I would like to, all right, so if we go around the table here, we'll call the roll.
Craig Rush, present. Jim Talon, present.
Amanda Alexander, present.
Tom Boyd, present. Eric Kuhn, present.
Well, yes.
Bill Peters, present. Brett Lane, present.
Rob Cuban, present. Bill Wessel, present.
Mike Miller, present. Tim Miller, present.
Sylvia Santana,
John Thomas, present. As prosecutor, Nassau.
Top Reagan, present.
Cheryl Cludia, present.
All right, thank you, everyone, for your participation. Thank you for making a really hard check here. We're trying to see so for that, it really is important to be here. I do want to offer a little welcome to everyone joining us, joining the part of participating in this national meeting. This is a public process. We're live streaming this meeting online for folks who are not able to be here physically, but who want to participate. This afternoon, we will do our first public comment period for being part of every meeting going forward. So we're really appreciative of that. You know, we do get the some of those are having trouble
Please speak up.
We're going to work on the radio and come back in and see if we can get the sound system fixed. Until then, everyone's just going to have to speak a little bit louder.
So, is this a little better?
Yeah.
Good. So I want to thank all of you for joining us. This is a public process, and we appreciate everyone's participation. And just I want to emphasize that the issues facing our county jail system affect the entire state of Michigan. This is not merely an urban issue. This is not merely a rural issue. It's a collective challenge that we all are coming forward to address. Every member of this task force represents a different element of a possible solution or a set of possible solutions to the challenge that we face. So we're proud to be here at the table together and also be part of the process with all of you. So with that, we have some business to take care of in a minute.
We have a motion with respect to the minutes from the July meeting. Second. All in favor of approving the minutes from the July meeting?
Aye.
We have brief report outs from some roundtables that have already met. Bill Peters and Jim Talon are going to give us first report from the County Commissioners Roundtable. I'm proud to speak up. Is that better? Okay. Jim and Bill, can you please give us a brief report?
I'll start out, and I used to teach first grade, so I'll use that voice that I used back in the day. We had a great listening session at the end of our Michigan Association of Counties conference on Tuesday. We had 13 commissioners. We primarily targeted commissioners from northern Michigan and the UP. It was an hour and a half discussion, very lively. Bill kind of summarized, I don't know if you caught it at the end of his welcome, the primary thing we heard from those commissioners and administrators from the northern counties is the shortage of mental health and substance use disorder services. And related to that, because of the shortage of treatment beds, they end up, when there is an opening in a bed, having to take someone pretty far away. So that takes away resources when an officer has to transport someone. So it becomes even more complicated in that regard in terms of cost. But people talked about too many folks being held for low-level offenses, things that we've also heard, or being held for failure to pay fines and costs. We talked about overcrowding isn't as big an issue in the northern Michigan county jails, but there's an extreme diversity of needs that they haven't seen before. And several people noted more women are being held in jails than in the past. There were two operational and funding issues that were talked about. They find it very hard to attract and retain correctional officers. They tend to come in, they get trained, they're there for a while, and then they go somewhere like a big city where they end up getting paid more. So that's a problem in the northern counties. And jail costs in a small county are way too proportionally high in the total county budget. So, and they talked about high medical costs. And I think most of us, whether we're urban or rural counties, are experiencing that in our jail. So that's a quick summary of takeaways from that, and we'll have more things that will contribute, I'm sure, along the way. Bill, anything to add? Okay, thanks.
Perfect, thank you. Judge Boyd, do you and Judge Gibson want to give us an update on the judges committee?
Judge Edwards and I conferred about this, and I'm ready to do the report. So what we've done, I've got three points really. What we've done since our last meeting is we've had a judges committee meeting with the Chief Justice's leadership. Judge Edwards and I formed a 20-person judges committee of judges from district and circuit court from all around the state. And we met on Friday, August the 9th, to talk about the original presentation to the task force. And just this week at the Michigan District Judges Association Conference, we had two separate sessions talking about pretrial release to create a dialogue with people who are actually making the bond and release determinations on a regular basis. Second point is we firmly believe that judges can help shape, understand, and contextualize the data that our good friends from Pew are putting together. We understand that data collection from the 82 county jails is very difficult, but we have some specific questions, things we'd like to know. We will work with the folks from Pew, but a partial list of this information includes what percentage of the folks in our jails suffer from mental illness, which mental illnesses are being treated in our jails, what percentage of the folks incarcerated suffer from a primary diagnosis of substance abuse disorder or are currently homeless or were homeless at the time they were incarcerated. We also talked at the last task force meeting about shifting trends in jail utilization, where the urban and rural populations shifted in the amount of growth. And we're wondering what percentage of that is rural communities renting beds to urban communities. We wonder how much of this is the phenomenon relates to structural problems like county budgets, because sometimes sheriffs are under a lot of pressure to keep their beds full. It's an economic reality that people don't want to talk about, but it's tough for sheriffs to make their budget when they're also trying to keep people in the community. We'd like to see some data points added to the data history, like for instance, when did sentencing guidelines begin? So if we look at the jail trends and the crime trends start from the last task force meeting, if we could put on there, when did circuit court judges have to use sentencing guidelines? If we can add when did hospitals like this one, Final Lafayette Clinic in 1993, when did they each come offline and how did that affect jail populations in real time? There's a current DOC policy, whether it's written somewhere or not, but they don't want to send people to prison. So we've got judges that say, well, I get a sentencing, pre-sentence report from an MDOC probation parole officer that says, 12 months in a county jail. But they'll come to my office and say, this person needs to be in prison, but I'm not allowed to write them. So there's a DOC policy, whether it's expressed or implied, that is forcing people into the jails because they don't want them in the prisons. What's really going on there, and what can we find out about that? Finally, we think the judges can and will be helpful with problem solving in the future going forward. We really need to look at transferring our investment in jails into tethers and drug testing and mental health and similar technologies and programs that keep people in the community where they can exist safely if we reallocate the resources to properly support them and monitor them. The judges that we've met with have expressed great interest in change and they believe in the need for change. However, they constantly remind us to be mindful of the potential erosion of judicial discretion and the real need for a human being to make a determination on pretrial release. We need better information in making bond determinations that is a bolstered pretrial services support system in many of the counties. So in a meeting with judges from all over the state, someone from Oklahoma County will say, well, this is what I have when I'm setting a bond. And everybody else will put their jaw off the floor and say, you have what? So in Ingham County, every Thursday, I get a list of people that are in jail under my authority. And I say that to people in Wayne County, and they say, you get what? So there's just a disparate, level of resources across the system. And finally, we join everyone else's call in renewed investment in mental health services and a review of how we support people with mental illness who are functioning.
Thank you, Judge. Anything you want to add, Judge? Okay, I think that we're done with our business items, and we can move to our first presentation. And I think, Terry, you're going to introduce our presenter. Is that correct?
That's right. So we're going to keep working on the sound. Sorry about that. And we'll ask our first speaker to speak extra loud until we have all microphones worked out. This task force has been directed to do several things, and one of the specific directives is to better align practices with research and constitutional principles. And so the technical assistance staff was asked, how can we sort of present or package the information with this group so that everybody can be on the same page or the same basic knowledge about best research in the field on jail interventions and jail alternatives, the best of the constitutional principles and the landscape, particularly around active litigation. There's a lot of litigation around the country related to pretrial decisions, and you all should know about it. So technical assistance staff, we've read a lot of studies, we've read a lot of legal research, and we've read a lot of case law, but we're still not experts, so we thought, I'm trying to bring in some experts from today. We brought in three. So the first speaker is Tim Schnapke. He's from the Center for Legal and Evidence-Based Practices in Colorado. He wrote the book on the history of bail, fundamentals of bail. He is the leading scholar in the field on what could a model bail policy look like based on that history of those fundamentals. For the case law, we brought in somebody who's right in the middle of it, who has the best sense, as far as I can tell, of here is the landscape of the litigation across the country. Here are the trends.
We can't hear you.
The second presentation, we have somebody who is an expert on the active litigation across the country related to bail and pretrial decisions. I know her interviews from our work together on the Uniform Law Commission. There's a committee on pretrial release and detention, and every time she opens her mouth, I think, oh, she's the smartest person in this room, and I wanted to make sure you all heard from her. And then the third person that we brought today is Jennifer Kopp. Jennifer Kopp is the director of the Jail Research and Policy Institute at Florida State University. She's written extensively on and conducted studies on intimate partner violence, and she has worked with the Future Trust on a massive literature review on jail and jail alternatives, arrest and arrest alternatives, interventions for crime victims who are in the pretrial period, and she's here to present a summary of that research with you today. So we're going to kick it off with Tim Schnapke and Steve Black.
Thank you, Terry. Thank you, everybody here. It's a real honor to be here as part of this commission. This is a very important group. Taking on a very important topic, I've done full time now for a long time, but you should realize that before bail reform, before I started to do this issue, bail, no bail, that sort of thing, I went around the country and did jail assessments for the National Institute of Corrections, who look at jails and help sheriffs for the most part with crowding issues. And so we look at whole system issues. And I know you're looking beyond the pretrial phase of the case. You're looking at everything. But realize that every time we went to a jail, what we saw over and over again was that the pretrial population was something that had to be dealt with. And so very quickly, and then it's been now 13 years, this is all I've done. Before I did that, I didn't know anything about it. I came out to a blank slate. And so I was fairly neutral when I started. You may not think I'm neutral now, but that's just because I've looked into it a lot. But I appreciate it. If you'll bear with me, I know we have time. And I know that if you allow me to wait until the end to ask your questions, because it's the way this presentation works, it kind of builds on itself. And sometimes people will ask a question and I'll say, oh, hang on, answer that 2 minutes, that kind of thing. So give me that much break and then we'll get to the end. I guarantee you we'll have time for questions. I've been asked to talk about this, legal and historical foundations of pretrial justice. I like this topic a lot. And the reason I like it right off the bat is because it allows me to talk about this phrase, legal and evidence-based practice. Now, everybody in the country wants to do evidence-based practice, right? That's all it is finding out what research tells me what to do. What does the evidence say I should do to achieve my goals? But when you see this phrase, this is code for bail and no bail, release and detention. This is what we do. It was coined by a researcher named Marie Van Nostrand. And she's a really well-known bail researcher. She was looking at the post-conviction research and asking herself, can we apply this to the pretrial phase of the case? And she said, well, you kind of can, but not really. Because of the laws keep stepping in and telling you got to do it differently. And so she came up with this phrase, and I said, wait, that's fantastic. Because sometimes the research will tell you what to do, but the law comes swooping in and say, yeah, but you can't do it, it's unfair. I also liked it because the word legal is front and center. You're going to find out today, the law and bail has been dormant for 180 years. Making a comeback, you're going to hear from Andy. I thought this was such an important phrase. That's what I call my little nonprofit. Center for Nobody Can Pronounce It. That's what I call it. Center for Legal and Based Practices. People say, well, that's what I want to do. What do I need to know? Why do I need to know it? And I say, if you want to do legal and evidence-based practices, you need to know the fundamentals of bail. And the fundamentals are simply 6 big subject matter areas you have to learn sort of an equal measure. It's a little like being a drug court judge, where you might have to learn something more. But if you know them, I guarantee you can do anything. Anything from recommending a condition to a judge, all the way to changing your constitution. Good news is you don't have to write them down. I already wrote them down. In 2014, the National Institute of Corrections asked me to write 2 papers, and the first one is just fundamentals of bail. It tells you what they are. It's a good paper to just read for anyone. They don't have the system. Second paper, I said to myself, well, if you follow the fundamentals of bail, how would you set bail? And I wrote that for judges. I've mostly only worked with judges my whole life. State Court of Appeals, Federal Court of Appeals. So I said, well, let's do that. Let's write a paper where it says how you would set bail. And it turns out the answer is, if you follow the fundamentals of bail, the way you'll set bail is it's going to be an in or out decision. Immediately effectuated, with nothing standing in the way of the in or the out. When I wrote these papers, I said, by the way, though, you may have to change all your laws. What are the fundamentals? Here they are. Why change it all? What's the problem? If you know the problem, you're halfway to the solution. And I spent the first 7 years doing this, just trying to convince people there was a problem. The history of that, legal foundation, we'll touch on those today. This is why they're important. The pretrial research, you're going to get some research today. It's very important to know all the research, outcome research. You can have every bit of research is relevant today. Opinion research, outcome research, operational research, legal historical research, social science research, risk research. The national standards are fundamental. I won't be able to talk about them, but they are the epitome of legal and evidence-based recommendations. The American Bar Association has a set, and the National Association of Pretrial Services Agencies has a set. They'll say, in fact, this is what they're great. They say, do this, footnote, because the law says this and the research says that. So they're legal and evidence-based. And finally, terms and phrases of bail. And this is really important. This is the reason why the NIC asked me to do this paper. Because they would go around the country and I'd be with them. We'd be in a room like this, and let's say every one of you here is from a different state. And we'd be talking about pretrial justice. And inevitably, someone would stand up and say, well, I know how to achieve pretrial justice. We have to eliminate bail. And if you were lucky, someone else would stand up and go, well, we can't do that. We have a right to bail. It's in our Constitution. What's the problem? The problem is they were defining it differently. The person who wanted to eliminate it defined it as money. This other person defines it as something else. It turns out, if you know all the fundamentals of bail, they point to universally true definitions of terms of phrases. That's really important to know. Because if you know the universally true, I call them the legal and historical definitions, if you know them, the rest of the fundamentals will make sense to you. If you don't know them, some of the other fundamentals won't. The legal and historical definition of bail is that it's a process of conditional release. Why do we have bail? We have bail historically to get people out of jail. Why do we have no bail? We have no bail to keep people in jail. If you think bail is money, like a lot of states think, you'll be confused when you read a Supreme Court opinion. For instance, Stack versus Boyle, that says that equates the right to bail with the right to release before trial. So you can see what terms and phrases are important. And realize that when I talk about bail and no bail, I'm going to use the legal and historical definition. I will be talking about bail is release, no bail is detention. Big issue you're going to face no matter what you do in the pretrial phase of the case, you're going to have to deal with money. And by money, I don't just mean any kind of money bail. I mean one particular kind called the secured financial condition. You guys know what a secured financial condition is. That's the thing that says you have to put down something to get out of jail. Might be cash, might be property, might be a fee. The secured financial conditions at bail, if you hold them up merely to the other fundamentals of bail, you're going to see that they got problems. Historically, we haven't really been using secured financial conditions in bail since 1900. And they've been flawed ever since. There are things about the constitutional claims. The research says they don't work, and the standards say you shouldn't use it. In fact, financial conditions that are in secured form cause problems at both ends of the spectrum. Now, I didn't make up this quote. This came from Chief Justice Radner from the New Jersey Supreme Court. He had a group just like this group. They studied bail and no bail for over a year. And they came up with recommendations. And on the very first page of the recommendations, they said, these secured financial conditions cause problems at both ends of the spectrum. And the first end of the spectrum is illustrated by this guy. This is Leslie Chu. He is what we would call today a low-risk defendant. He didn't have criminal history. He had a job. He had a car. Now, he was poor. He lived in his car. And he was working down in Houston, down in the oil field down there. One night it got cold. So he went and shoplifted a blanket. And he got caught immediately. And I don't know if they took him to a place where you have like a bail savings here in Michigan, you know, a piece of paper that says the charge of the amount of money, or if a judge set this amount. But his amount to the secured financial condition was $3,500. Well, he didn't have that. He didn't have $350. I suppose he'd have bought the blanket. So he stayed in jail about 8 months. We had his picture because NPR did a story. I put it up here because this happens every single day in America. It affects poor people, it affects communities of color, it affects minorities. It just affects so many people every single day. It's a huge problem in America. But by the way, this also happens. Maurice Lemons assaulted a police officer. He went before the judge, and the judge said, this is really serious. I'm going to set your financial condition of bond at $40,000. But Maurice had money. He knew of bonds when he got out. And within a week, they arrested him again, this time for accused of raping 2 small girls. So when he came back to the jail, he said, oh, we better look at this guy, we better interview him and assess it. They went back to the judge and they said, Your Honor, this is highly likely to be a man. He's incredibly dangerous. He's going crazy. His family's all worried about him. He started calling himself certain titles. And right at that moment, the judge said, I suppose what judges have done in America for 180 years or so. And maybe this judge thought with $40,000 that didn't do it. I'm going to set your financial condition of bond at $190,000. That'll do. Well, Maurice had money. He knew of bonds when he got out. And within a week, he went to Parkland, Washington, walked into a cafe, shot and killed his 4 officers. We have problems with bail or release, with no bail or detention. And the root cause is how we deal with these things called secured financial conditions. Money is everywhere in bail. It's so prevalent. Like I said, some states define bail as money. The question is, does it have to be? And the answer is no, it doesn't have to be. And the reason I know that is because I know the fundamental of bail called the history of bail. And if you know the history of bail, what I like about it is that it helps you understand bail reform. If you understand bail reform, then you'll know how we get into generations of bail reform. You'll know how to get out of it. We're in a generation of bail reform right now. You'll know how to get out of this. you'll know how to avoid them in the future. And to understand bail reform, all I have to do is take you back to 1274 in England. That's not so bad. I used to do this where I take you back to 400 AD. That was horrible. You get a skid and everything. Everybody got this. And it's important to go back to England, though, because we got all our bail laws from England. And back in 1274, in England, you were either bailable or you were unbailable based on custom. So it's like a common law, right? That was the king. Anybody recognize him? Same guy from the movie. Edward I. He heard rumors they were doing bail poorly, this man. So he sent out 100 inquisitors and he said, go out and find out what's going on. And they came back and said, Your Highness, things are bad out there. I said, what's going on? They said, well, you know sheriffs are your bail setters, right? Yeah, I knew that. Well, people are showing up on the sheriff's doorstep and they're customarily bailable. But the sheriffs are looking at them and saying, I know you're customarily bailable, but I'm not going to let you out of jail unless you give me some money. Other people are showing up on the sheriff's doorstep and they're customarily unbailable. And the sheriffs are looking at them and saying, I know you're customarily unbailable, but I'll let you out if you just give me some money. Listen to me, everybody in there. I like to say the king was royally tipped. Parliament was upset. They passed the Statute of Westminster in 1275. And the Statute of Westminster said that from now on, there's no custom. You're either bailable or you're unbailable pursuant to the statute. And if you're bailable, sheriff, you've got to release them. Bail means release. If you're unbailable, sheriff, you've got to detain them. No bail means detention. And you can't take any money. And if you screw this up, sheriff, we'll put you in jail. The Statute of Westminster created the first legislatively articulated bail, no bail dichotomy. That's why I have that. Props. You're either bailable or you're unbailable. Now, bail, no bail is very important because it still exists today. Everywhere you go, all you have to do in your case is look in your Constitution. All persons are bailable except no bail. But that's not the thing that helps you understand bail reform. The thing that helps you understand bail reform is this second notion that says if you're bailable, you're supposed to be released. Just like if you're unbailable, you're supposed to be detained. In fact, that's such an important concept. All through the history of bail in England and America, if anything gets in the way of bail is release or no bail is detention, you see bail reform happen. Now, every so often it happens with no bail. Every so often someone will look at the no bail bucket and say, we think these people should be in there, or maybe we should add this process to it. That happens. But mostly it happens with bail or release. Throughout history, most bail reform happens because bailable defendants are in jail. In fact, that's a rule of thumb. Historically speaking, if you see bailable defendants in jail, you can almost guarantee that bail reform is swirling around above you somewhere. Now, we did no bail the same way then as we do today. We locked you up. We think we did it better. We do it better today. We think we do it fairer and we have some better process. But we did bail or release completely different. Back then we used what's called the personal surety system. Has anybody heard of that? Personal surety system had three elements. First, the sheriff would have to go find a person. Maybe three people. Maybe these three people here would be our sureties. Because I'm the defendant, I'm going to really risky or dicey in some way. So we find a person, they have to agree to watch over me, take responsibility for me, make sure I come back and face justice under what we call a continued custody arrangement. And third, they weren't allowed to make any money. Couldn't profit from this deal. Couldn't even be paid back. If you ended up having to shell out any money as a surety, they couldn't even pay you back. Money was not allowed in the bail process except in that little tiny thing that today we call your financial condition of your bond. Now that had always been there. Going back to 400 AD, we've always had something hanging over your head to get you to come back and face justice. Before money was property, before property it was people. But get this. For hundreds and hundreds and hundreds of years, all through the history of England, all through the history of America, all the way up to the 1800s, this financial condition of bond had only ever been what we call today an unsecured financial condition.
Exactly. You don't have to put anything down to get out of jail. People make promises to pay. Sureties promise to pay. Sometimes the defendant is surety promise to pay. And that's how we made sure bailable defendants got out of jail. The big rule that says bailable defendants have to be released. How do we do it? We use personal sureties and what we call today unsecured bonds. And when we moved it over to America, we like all of it. We said, this is great. Bail is released, no bail is detention. We like all of it, we'll stick it in our laws. In fact, we're America, man. We're going to do a few things different. We did 3 different things. First thing we did is we made bail much broader. We said we're going to make the right to bail broader and broader. Pretty soon, everybody was bailable except for capital defendants. And then we started chipping away at the crimes that were capital crimes. The second thing we do, it's a little confusing. I call it bright line bailability. What's that? Well, after the Statute of Westminster, after several hundred years, some discretion started seeping into the bail system in England. To the point where, in some cases, a sheriff and later a judge could look at somebody and say, well, based on your criminal history that I see here, I'm going to declare you to be bailable. And then I'll release you. Or unbailable. Well, it's easy to follow a rule, right? That says everybody that's bailable gets out. If you can decide who's bailable. America did not like that discretion. So America said, no, we're not going to do that. We're going to use what we call bright line bailability. We're going to lay out the charges, and the charges will be there, and if you're bailable, you just get out. No bail provision is going to be the only people you can take. And people asked them, they said, well, what about this dicey criminal history, this criminal history that shows how risky this person might be? And then America said, well, that's what you use to move the money condition up and down. But remember, the money couldn't keep you in back then. The money was merely a promise to pay. The last thing we did was we added a thing. We said, well, we're America. In fact, we want to leave a way out. Even if you're in the no bail bucket, we're going to still allow them to get out in some cases. So we added what I call the further limiting process. What's that? That's just an additional finding you have to make to keep that person in. The very first one, I mean, you've heard these before, it was proof evident presumption of rape. The very first bail, no bail dichotomies in America would say everybody's bailable except capital defendants, but only when the proof is evident and the presumption great. If the proof's not evident, the presumption's not great, even they get out. Technically speaking, everybody in America is eligible for release. It's always been that. When you looked at a no bail provision, then what are you looking at? When it was created, no bail meant this was our way, our state's articulation of who we're going to keep in jail on purpose using prediction. It was prevented detention. Back then it was only for flight. And this whole thing in America worked great. It worked phenomenally well. All bailable defendants the whole thing worked great right until the 1800s. In the 1800s, the funny thing started to happen. We started learning out of those personal sureties. Those people were willing to look over the defendant. Well, what's that cause? That causes bailable defendants to be in jail, doesn't it? What's that cause? That causes bail reform to happen. And so, we needed to do something. It happened in England and America, and England decided to pass a law saying, well, let's allow people to get out with no sureties, and that's okay. But in America, we went a completely different way. America said, why don't we chip away at those laws that say you can't profit from bail? Let's chip away at those laws that say you can't be indemnified for a surety. Essentially what we did is we switched to the commercial surety system right around 1900. I realized why we did that. We did that to help get bailable defendants out of jail. But when we did that, we did something that I don't think we saw coming. Because remember, for hundreds and hundreds and hundreds of years, all through the history of England and America, all the way until the 1800s, the financial condition of bond had only ever been what we call an unsecured financial condition. Well, now under this new model, this was almost always going to be what we call a secured financial condition. What's that do? That means people still can't get out of jail. Now they don't have personal sureties. Now there's another hurdle in the form of maybe fee or collateral. What's that cause? That causes bailable defendants to be in jail. And so then again, bail reform happens. And we have what historians call in America the first generation of bail reform. Now, why don't I call that earlier thing a generation of bail reform? We moved from personal sureties to commercial sureties, right? That should have been an era of bail reform, but nobody calls it that. The historians are certain of this. I'm convinced it's because it never worked. By the way, they say 1920s and 1960s. Decades. Bail reform generations take decades. It never worked. Our first commercial bail entity started in 1900. By 1920, we start to see papers from some really smart people. Roscoe Pound, Felix Frankfurter saying, oops, we've done something wrong here. We need to fix it. So we spent all these decades, once again, figuring out how to get bail defendants out of jail. All you have to remember today is we had a first generation of bail reform focused on release bail. Now we had a second generation too. That says from the 60s to the 80s. This is an interesting one because there were people that were getting out on bail that they were committing crimes. And a group of folks said, we don't want them out on bail, we want them in the no bail bucket. And another group of folks said, well, okay, well, how are you going to do that? And the first group said, well, we're going to make a prediction if they're going to commit a crime, and then we'll put them in the bucket. And the second group said, it's like, America, what are you talking about? Yeah, and by the way, public safety, that's not even a valid consideration. The only constitutionally valid reason for limiting pretrial freedom is court appearance or flight. Well, those are all good issues, right? Good questions. And they were all solved in the second generation bail reform. It turns out you can do all those things. You can enlarge your no bail bucket. You can put people in there with prediction of something they may or may not do in the future, and that can include future criminal activity. All you have to remember, we have two generations of bail reform. One that dealt with bail or release, one that dealt with no bail or detention. So why in the world are we here? We're in what we call the third generation of bail reform. There's different reasons, I'll just give you three. One is we know for a fact, there's not a single state in America to use everything we learned from those two generations to put together a package. Washington, D.C. is the only jurisdiction in America that's like that. Secondly, we got all this new research. You're going to hear about this research. It's game-changing research. Just saying the word for it, it throws everything about bail sort of up, and it's that alone would normally cost a generation of reform. But I'm convinced it's number 3 here. Because if you go all the way back into the history of England and America, we still allow secured financial conditions to get in the way of both bail and no bail. That automatically means we're going to have bail reform until we fix it. Third generation is pretty easy. These days, what we do is we go into a state and say, well, what is your bail, no bail dichotomy? What do you have on your Constitution? And some people will say, well, in Michigan, everybody's bailable except we have certain no bail categories. But by the way, in Michigan, we allow money, and so this gets, sometimes we ignore this no bail part, and so it's kind of all convoluted. We try to work with states to figure out who it is you think should be detained and released on purpose. Using prediction. Once you do that, all you do is apply these legal and evidence-based practices. It's pretty easy after that. The key to understanding bail reform is that both bail and no bail in America are okay. When we do the right. We don't do the right now in America, and that's why we are in a generation of bail reform. The old way we look at charge for not some money. The way we're not see what happens. New way, people are starting to look at different ways of looking at defendant's risk. The idea of charge as a proxy for risk is not necessarily a good one. We use less or no money because that gets in the way. We're doing things on purpose. But realize when I start to talk about risk, I'm going to show you this little guy twice today. And it's important, because you're very lucky that I realize this one. Normally I go to states and I say, oh my God, I feel bad for you guys, because you're going to have to do what I did, which is learn a lot about risk. You're going to have to be immersed in this horrible topic called defendant risk. And then Terry reminded me and said, no, what did that for? We'll help them accuse your staff. And that's fantastic. This is going to be helpful. The more that they can tell you about defendant risk, the more you will be comfortable with making the kind of line-drawing decisions that happen in an intentional system. Now, I found out this the hard way. Remember those 2 papers I said I already wrote? Remember I said I wrote fundamentals of bail, and then the other one, how how do you set bail? And I said, if you follow the fundamentals, you're going to do bail as an in and out process, intentional, nothing getting in the way. And I hinted, because you may have to change your laws. As soon as I wrote those papers, someone came to me and said, "You got to write a third paper. You're going to have to write one that says what they need to change those laws to." And I thought to myself, okay, I can do this. I'll do it all out. It'll take 10 pages. It's the easiest paper I ever wrote. I know what's going on. I read the bumper stickers. It says we're moving from charge to risk. I understand this. So what I'm going to do is I'm going to write a paper that says, all right, instead of this stuff, I'm going to say everybody gets released except high-risk people. In my limiting process, I'm going to say, let's use an actuarial tool to say who's high risk. It'll be 10 pages. Then I started writing this paper. And after about 6 months, I hit some big roadblocks. If you're only going to detain high-risk people, what do you do with a super low-risk person who's nonetheless in on a very high charge? We call that the son of Sam hypothetical, because the son of Sam scored a low on an actuarial tool. What about an incredibly high-risk person who is nonetheless in on a low charge? That implicates excessive bail, doesn't it? Now suddenly certain legal principles come in. The essence of excessive bail is there's certain crimes that perhaps the blunt hammer of detention just should not apply. And if we're talking about legal principles, then think about this one. Due process, fair notice. What's that? When America, the way we set up our criminal law procedure is we say, okay, everybody gets to walk free down the streets. And we'll set the laws up on the books. And if these laws are written well, they're not vague, they're clear, they'll give you fair notice. So that you can know how to manage your lives to stay out of trouble, to stay out of jail. That's how it's all set up. If I say everybody gets released except high-risk people, what's your first question? How in the world do I keep from being high risk? The answer is you can't. You're already high risk or low risk, we don't know. You just have to assess. Wait for you to do something. That's a big deal. That's a big deal when it came to my paper. And by the way, I've got issues also with the further limiting process. Now, if you're going to use an actuarial tool to detain people, it better be tight, right? Better be good. Now, you're going to hear about a debate. There's a big debate in America whether to use these things or not. And you can decide, you make that decision on yourself. But realize I'm on record of saying I think actuarial tools are wonderful for all aspects of release. But when it comes to detention, they need to be tight. And I ran into some problems. One is these tools don't tell you what I call individual risk. What's that? Well, in Colorado, let's use the Colorado tool as an example. You're either 1 through 4. 4 is the highest risk person we have. It's just higher than the rest. If Terry is a 4, what does that tell me? Is he high risk? No, we don't know. But it tells us that Terry looks like a group of people who, when they were assessed, showed a certain level of success, right? Performed a certain way. We don't know what Terry's going to do. He could be the highest risk or the lowest risk person in the world. Okay, that's helpful to know when you're releasing people, right? If you know people's risk compared to other people, you can do things to help them. You can actually help them. But when it comes to detention, that's pretty loose. How about this? They don't tell you risk of what? What's that? Well, in the same sense, if Terry's a 4 on the CPAT, on the Colorado tool, when it comes to court appearance, that tells me that he's higher than everyone else to not show up for any court date for any reason. Could be bus troubles, could be child care issues. Now, when it comes to release, that's helpful. I want to know if he's higher risk than everybody else, because I can help him get to court. But when it comes to detention, we've never detained for just any old court date. What do we detain for in America when it comes to court appearance? We detain for extreme risk of willful flight to avoid prosecution. We detain for this in court for any old reason. What about public safety? Same thing. On the CPAT, if you're a 4, that means you are higher than anyone else to commit anything from a traffic violation to murder. When it comes to release, that's helpful. When it comes to detention, though, we've never detained anyone in America on purpose using prediction or anything except extreme risk of flight to avoid prosecution or extreme risk of committing a serious or violent crime
while on release. So the tools can be very helpful, but when it comes to detention, they pose problems. Suddenly, my 10-page paper is now 200 pages. But you can get it on the website. And I figured it all out. What is that? Yeah, I'm not going to sell it. I'm the trunk of the cards. The model bail laws is the 200-page paper. Changing bail laws is a 60-page summary of that paper. Realize there's certain big issues that we have. America was heading down the path of saying, if you're high risk on a tool, we can detain you. We turned that ship around. We did it by writing this big, long paper. Realize that certain things you just have to deal with. One is, I don't think you can have, I think you have to have a charge-based detention of that. Just certain things like that. Your limiting process needs to be better than any other limiting process we've ever used in America. So I propose a brand new, but it answers the risk of what question. It answers the aggregate versus individual risk issue. It's a long paper, but realize that it's there, and I think we have the answers. Why do I call it Plan B? I call it Plan B because if money goes away in America as a detention mechanism, then all you're left with in terms of who you can detain pretrial is your no bail provision. And a lot of states, when they realize this, suddenly go, oh, really? Maybe we should change it. So you need to realize if money goes away, I call this Plan B, and I tell people, I can do straight. I'm doing okay, right?
Oh, this is for posterity. Can you hear this? Oh, this is exciting. So read model, read changing. I call it Plan B because if money goes away as a detention mechanism, you will be left with your only articulation of who you can detain pretrial. I think that's not enough. I'm pulling it back. On purpose, using prediction. And realize working on Plan B is something I tell every state to do no matter what else you're doing. Simply because Andrea is going to talk about a number of cases that are forcing people down that road. Now let me take a quick turn and talk about legal foundations of pretrial justice. And very quickly I'll tell you three very quick things about it. One is if you know the legal foundations, learn the history. The history and the law are best known together. But that just follows from what I said about fundamentals, right? Knowing them all. It just needs a little low end, or less struggle. Secondly, this is going to be your source. This is how you do bail in Michigan. A lot of people invite me to their states and they say, oh, come tell us what New Jersey did. Tell us what New Mexico did. And I say, well, I can do that, but you may not be able to do that. Your source is going to come from here. It's going to be different than every other state. So the bottom line is you need to know your own mix. It's helpful to know other state mixes. And finally, the law of bail is incredibly sparse. We really only have 2 U.S. Supreme Court cases in bail. Isn't that weird? Well, I think if you only have 2 cases, wouldn't you think that we'd quote from them at parties? You know, we'd have them hung up on our walls. But no, we ignore them. I'll give you 2 examples. Who here thinks criminal justice should be non-arbitrary? It's a trick question. Raise them high. How do you keep things from being non-arbitrary? You have standards. If you have standards and they're objective and lawful standards, then when you put defendants into the standards, then the differing treatment they get is okay. The death penalty is the perfect example of this in criminal justice. The Supreme Court says death can never be arbitrarily administered, and therefore we have tons of Supreme Court cases dealing with how states administer the death penalty. Well, bail is supposed to be the same way. Uh-oh, we lost everything now. I'll have to remember where I am. In 1951, the U.S. Supreme Court said, in Stack versus Boyle, the first case we ignore, because the function of bail is limited, you have to have standards. Those standards have to be applied to every single person in every case. And when they said that, every state knew what they were talking about, so they passed what I call the factors. You've seen these, they're in your law. I've seen them. It says in every single case, the judge sets bail, they have to consider the following things. Criminal history, community ties, they're all in there. We had 16 in Colorado. Judge shall consider the following 16 things. But guess how we set bail in Colorado for decades? We use bail schedules. Charging money, charging money, charging money. What about the factors? We ignored them. What about the case? We ignored that. What about the bigger issue, right? Making sure that bail is not arbitrary. We ignored that. The good thing is, once I started talking to our jurisdiction about bail schedules in that way, they decided to get rid of it immediately. Now, there's other reasons for getting rid of bail schedules, but this is part of the fundamentals of bail. It's going back in time. Now, you have to, normally I would click and show you the next thing. In addition to that happens all the time in America, this other thing happens more often. Remember in the second generation of bail reform, when I said it's okay to enlarge your no bail bucket, you can put people in there based on prediction of something you may or may not do in the future. But because that was practically un-American, the Supreme Court, in the second case that we ignored called Salerno, the Supreme Court said, and this was a conservative court, by the way, it was Justice Rehnquist, he said, you gotta remember two things. If you're gonna put people in there based on prediction, you gotta make sure it's really, really limited. What's that mean? They say carefully limited. It just means it's just not supposed to happen very often. Liberty is supposed to be the norm. Detention is not supposed to happen very often because it's on-purpose detention based on prediction. The second thing is it's got to be really, really fair. And when they looked at the federal act, they said with fairness, they liked the fact that it was an adversarial hearing, a full-blown adversarial hearing with defense attorneys involved, with cross-examination of witnesses, all this stuff, because it's not supposed to happen very often. It's based on prediction. But I can go into a courthouse anywhere in the United States and watch a defendant get detained in 8 seconds with no due process. All it takes is to read a line or two and to set an amount of money. And that causes a problem. Let's see if this thing comes up. I have a really great picture coming up here. But it's hard to find a good picture for this thing. Right about this time, even though I've said hold your questions, every time I start talking about it, right at this time, I'll get the same question. And the question is this. They'll say, no, wait a second, Tim. You said earlier that in the history of bail, if you see bailable defendants in jail, bail reform happens. It's a marker of bail reform, yeah. And now you're starting to tell me that there's certain legal foundations that get in the way, that maybe having bailable defendants in jail which cause legal problems. And so the question is this. Someone will stand up and go, I don't get it, man. We've always had bailable defendants in jail, right? Ever since I was a kid, there have been bailable defendants in jail. My grandfather, when he was a kid, he told me there were bailable defendants in jail. How can that possibly be unlawful? If that were unlawful, then, America would have fixed it by now. How can that be? And the answer, the only way to understand this is for me to explain a concept known as the excessive bail loophole. Now, this is probably one of the most important legal concepts you can think of because it's the one thing standing in the way of almost everything we're doing in bail reform. How do I explain the excessive bail loophole? I got to take you back one last time into history. Remember back in the 1800s, and I said that judges were running out of their personal sureties? And I said, well, they had to do something. Bailable defendants were in jail. We have to do something. Well, we were 70 years away from turning to commercial sureties. Our ultimate answer was that we had to do something between then and 70 years from now. So they tried a different thing. Well, the first thing they tried actually was said, let's see if these defendants can promise to pay the amount on their own. And they all laughed at the water cooler. They said, that's just silly talk. The second thing they tried, ooh, we're there. Look at that. I'll show you a good picture. That's the guy asking the question. There's the loophole, see? The second thing they tried, they said, let's see if the defendant can pay this amount of money himself. See, it was the first secured financial condition. And they couldn't pay it themselves, could they? And so all these claims started coming up through the system. And you can imagine what they all said. They said the same thing. They said, this is excessive bail. It's excessive because I can't afford it. I have a right to bail I can afford. And right at that moment, in the history of America, the excessive bail clause of the U.S. Constitution or of any state constitution could have swooped in and said, you're right. It's excessive if it's unaffordable. And had that happened, all of our bail laws would have grown up around that, and we wouldn't even be here today. That's not what happened, is it? No, all across America, judges held it's not necessarily excessive just because you can't afford to pay it. You've heard it said this way, you don't have a right to bail you can make. Okay, what makes it a loophole? What makes it a loophole is that these cases really only apply in one way to unintentional detention versus intentional detention. Okay, how does it apply to unintentional detention? What's that? Unintentional detention is when a judge looks at you, let's say I'm looking at Terry, again, he's my defendant, and I say, Terry, I really want you to get out of jail. I mean, I really, really do. So much so that I'm going to sign this order of release, and because bail is a process of conditional release, I'm going to set some conditions. Now, one of the conditions is you're going to pay $6 million in cash. But I really want you to get out. It's just that $6 million is important to me. It's what gives me reasonable assurance that you're going to come back. When that happens, the excessive bail cases say that's okay. And the resulting detention is just an unfortunate consequence of a conditional release system. But it doesn't apply to intentional detention. What does that mean? Well, that could happen a couple of ways. One, the judge could look at you and say, I see you're bailable, but I'm not going to set your bail at all. Reversed. Everywhere you go, that's reversed. You'll find it in your case law, usually back in the 1800s. Secondly, a judge say, okay, I got to set your bail if you're bailable. This is what I'll do. I'll set your bail. I'm going to sign that release order. And I'm going to set conditions. And you're going to pay that $6 million condition. But then he says this on the record, that I'm setting this condition to keep you in jail. I'm fearful for public safety. I'm worried you're not going to come back to court. And therefore, that's why I'm setting it. I want you to stay in jail. When that happens, reversed. And when these happen, all across the country, you see these. Intentional detention, they're all based on the same three rationales. You see them everywhere. They'll either say, the court will say, you can't keep bailable defendants in jail on purpose using money, because if you do that, you're just doing something dishonestly or indirectly that maybe you could have done honestly or directly over here. Or they'll say this, you can't keep bailable defendants in jail on purpose using money, because if you can do that, you've added an exception to the bail clause. We have the bail clause and we have exceptions to the bail clause. You can't just add to the Constitution. Or they say this, you can't keep bailable defendants in jail on purpose using money, because if you can do that, then you have eliminated, you have negated the no bail provision. So you see the loophole, right? If I'm a judge in America and I want to detain somebody, I can detain anybody I want. All I have to do, whoa, I can't see that even myself, is make the right record. If you make a record of intentional detention, it'll be reversed. If you don't make any record at all, you're allowed to keep them in. This has masked the need for bail reform in America, because people seem to think that somehow having a bailable defendant in jail is okay. When historically speaking, going all the way back to England, it's never been okay. It's always been a marker of bail reform. And this is really important when you think about this. When we came over from England and we said to ourselves, we don't want any discretion in the bail process. We want to put out who's bailable, and those people, there's no discretion, we want them released. Right now, the way we do bail, we have ultimate discretion built into the excessive bail cases. Now, this is all changing very, very quickly. That's a picture of fish, by the way. When you look up the word change and you try to find a picture to associate with that, they show you fish. I don't know why that is. Maybe because he's changing bowls. How is it changing? Well, one way it's changing is people are actually suing bail setters all across the country, and they're not even bringing up the excessive bail clause at all. They're just not even mentioning it. What are they saying? They're saying, well, we don't care if you're in there on purpose or unintentionally, intentionally, we don't care. If money keeps you in there, you're violating due process, either substantive or procedural, and Andrea will talk about that, or equal protection, because you're in there because you can't pay money and somebody else can get out because they can pay money. And they're winning. And in fact, the very first argument you see in every single case when this comes up is the people, the defendants say, no, no, judge, don't decide this under due process and equal protection. Decide it under the excessive bail clause. Why do they do that? Because the loophole allows it to work the way it's worked for 180 years. But the judges all across America are rejecting that, and they're finding violations of equal protection and due process. I'll only tell you two things. She's going to talk about the case. One is, the best example of this came out of Harris County, Texas. And you should realize that Harris County, which had constitutional violations, sets bail the way every single county in America sets bail. Second is, if this becomes the law in America, then money as a detention mechanism simply vanishes, it goes away. And if that happens, of course, you're left with what I told you, what's in your Constitution in terms of no bail. Whoa, okay. What do I have to look next? The future, of course, is more lawsuits, more groups, more legal theories. And you should take my word for this, by the way. These cases are not the only way money as a detention mechanism will go away. I've been predicting that money as a detention mechanism, not just globally, I mean as a way to keep people in jail, there's like 15 different ways it could happen. And a lot of times I'll come and list all the ways and just go through them. It takes about an hour. But I want to focus on one way, which is probably the most important way, which is if you decide as a state, as the people of Michigan decide, all we want to do is do things on purpose. If you simply decide we want to do things on purpose, we want to make a decision to release or detain someone on purpose, you are automatically heading towards not using money and towards relying on what's in your Constitution that says you can keep people in jail on purpose. The third, so that's two different big pressures to change. The third one, Andrea talked about too, but there's people that are wandering into states now, and they're actually attacking existing no bail provisions that are already on the books. Now, that's crazy, right? If on the one hand I tell you in Michigan, I say, by the way, people are taking away money. Right now you probably have a lot of people in jail that are in there on money. And if they take away money, I say, you're going to be left with your net to keep people in. That's who you're going to be left with, your detention eligibility net and your process. And then I tell you, people are coming in and they're throwing those out. They're constitutionally vulnerable. And by the way, I looked at your Constitution. It's constitutionally vulnerable. Then what do you do? Well, the best thing you might be able to do, you might have to do, is start with a complete clean slate. I mean, start from scratch. Now, I would never go into a state, here or anywhere else, even my state, and say, do this if I hadn't already done it. But I've already done it. Refer back to those two papers I gave you, Changing Bail Laws and Model Bail Laws. I created my own model detention law based on intention. It's a moneyless system. It's an in-or-out system. I think it holds up to constitutional scrutiny. At the very least, you're going to see issues in there that you're going to need to tackle if, in fact, you head down this road and try to do this stuff on purpose. If you do that, you're going to be asking the people from Pew lots and lots of questions about defendant risk. Because the more you understand defendant risk, the more comfortable you will be with drawing those lines. And it's a line drawing exercise. When you do things on purpose, you got to draw lines. Some of the stuff the research is going to tell you is counterintuitive, very counterintuitive. For instance, you're going to find out that defendants are simply not that risky. They're just not that risky. In fact, risk in bail is a misnomer. As a field, I'm going to zoom up. As a field, we are starting to quit using the word risk. We're just not using it anymore. Why is that? Well, if you look at these actuarial tools and you see the high-risk categories in every single tool, those defendants still succeed more than they fail. Sometimes at the 75% mark. We over-detain in America, I can guarantee you. So they're just not that risky. Secondly, if all we detain on is risk of willful flight to avoid prosecution and extreme risk to commit a serious or violent crime, well, those things hardly happen at all. And guess what? When you get to the point of hardly happening at all, you have problems with base rates. Meaning there's so few instances of it that you can't predict it anyway. So those are the kind of issues you're going to have to work through when you dive into this thing. But realize the whole issue of bail reform, or at least moving to an intentional release detain system, is simple. It's just not easy. The simplicity is you're just trying to figure out who do we release and who do we detain. You're drawing a line between 1 and 2. Now, you already have a line drawn in Michigan, and I know where your line is. I saw your Constitution. Now, you may say to yourself, yeah, but we don't pay attention to that line because money keeps people in. But you have a line. And if you want to redraw that line, the only way to start is to start plowing through my two papers, my recent ones. If you were building a Volkswagen Beetle, and I said, I have the document that helps you build that, you would read it. I'm trying to get people to read a paper that's long and difficult, so please try to. It has to be justified, by the way. Most of the stuff we're seeing in America, it's being thrown out there. You may see it in Michigan, who knows, in the future, is unjustified. People just say, this is who we want to detain, and they put no effort into it. They haven't thought it through. The easiest thing for an appellate court to do, especially a federal court of appeals like I used to work for, is to toss something out as if somebody has no justification for it. Now, the law and history together, and this is how we'll finish this thing up, tells me a few things. The most important thing, first of all, it tells you what bail is, right? I've already said that it tells you that bail is a process of conditional release. But the most important thing probably is it tells you this, which goes back to that concept of legal and evidence-based practices, right? Everybody wants to do evidence-based practices because it tells you how to do what your goals are. But when I started doing this bail reform work, nobody knew what the goals were. We didn't really know what to say. But the law and history together tell us what it is we're trying to do. Now, this is the most important slide I'll ever show you in my life. More important than any slide at my house and my vacations. So important that I'm going to show it to you 3 times very quickly. So important, I use 3 M's to burn it into your brain. So important that I have a picture of 3 M&Ms. Which is rare because, of course, they travel in pairs. Those are the 3. We're trying to maximize release, at the same time maximize court appearance, maximize public safety. Now, you're saying to yourself, well, wait a second, Tim. You said bail and no bail are both okay. What's the purpose of the whole thing together? And I say, okay, I would change the first M, and I would say that we are trying to maximize the appropriate placement of defendants pre-trial. We're trying to put people in the right place when you're thinking about both release and detention. It just so happens that this is where the law swoops in and says most people are supposed to be released, therefore you're going to mostly deal with this. We call this the balance of bail. They are competing purposes, aren't they? We have to worry about releasing people, and we have to worry about what they do while on release. The first one is a liberty interest. The second 2 are the constitutionally valid purposes for limiting pretrial freedom. This tells me 2 things. One is bail is inherently a judicial function. Why is that? Even though everybody should do the balance, everybody in this room should be constantly thinking of the 3 M's whenever they think of anything at bail. The reason it's inherently a judicial function is because judges are our balancers in criminal justice. They're held to error on appeal for not doing the balance. The second thing is it tells us that you can't just look at one and not the other. You have to always check all 3, and yet this happens a lot. You might get, in the future, you might get the 2020 Maximized Public Safety Bail Bill of Michigan, and you'll say to yourself, what? Oh, this is fantastic. That's one of the M's. But you're not done, right? You have to assess what that bail bill does for court appearance and release for you to make an intelligent decision about it. These 3 M's help you with all the research. The research that tells you how the thing they're looking at affects release rates, court appearance rates, and public safety rates. All 3 is better than research that doesn't. And now we're starting to see more and more what I call 3 M's research. Terry can help me find that stuff. It's where communities put together a package of improvements and they ask themselves, how did our release rates go? How did our court appearance rates go? How did our public safety rates go? These are our outcomes. These are our goals. Now, if I had to sum it up real fast, I'd say 2 things. One, anytime I start to see bail reform in America, what we're starting to see is people put together packages. That's actually a picture of a bunch of packages. Nobody ever just does one thing and says, let's try this for 6 years and measure it and decide what to do next. Now, they've come up with a lot of things. It might be court, it might be defense attorneys at first appearance, it might be working on the summons, it might be all kinds of things. And then they do these packages and then they try to research, look at them and how they affect those 3 M's. The second little picture that says 95 and 5%, I want to really reinforce this fact to you. Even though I spent a lot of time trying to scare you to death into thinking you need to do plan B, and look into your no bail provision and find out whether you think that needs to be changed or if you can leave it the same. By the way, New Jersey said they needed to change it. New Mexico said they needed to change it. California used my papers and said they didn't need to change it. Even though I've tried to scare you into that, you should realize you can do 95% of pretrial justice in America without even touching your constitutional no bail provision. Almost everything can be done without even getting to this. Now, I would still say do Plan B, because you don't know when these cases are going to come along that Andrea talks about and says, by the way, can't use money anymore. 95% of the stuff can be done without doing that. The last one is, if you do these things, all I can tell you is I'm rarely impressed by what a state does, but so far in Michigan I've been supremely impressed. I'm impressed by this group. I'm impressed by the makeup of this group. I'm impressed by just what I heard this morning. The fact that you have Q work helping you as staff. So far you're doing everything better than any other state has done. Just moving around in the state and hearing from people in the populace is a big move that I haven't seen before. So realize this, no pressure or anything, but you guys could lead the country in this whole thing. Everybody here should have a say as to who's in and who's out. So get to know these things about this constitutional stuff, get to know these issues. Thank you for having me. The last thing I'll tell you, that's just a slide saying, invite the little red guy who knows the fundamentals into your blue booth, and your recommendations will be different. Let's put it that way. I don't know if we have time for questions. How much time do we have? If only questions from the task force members only, and 5 minutes to do it, so that Andrea has all the time. I once had someone ask me about the Magna Carta. I once had a group from Georgia, not the state, the country of Georgia, through an interpreter, asked me a question about the history of bail in America. That was fascinating too.
When someone is released into the community, does any of your recommendations affect the other conditions, say drug testing and wearing a tether and things like that, or is that separate from the constitutionality of the bail consideration?
My main focus in my particular work is almost always just with the constitutional aspect. I've just gotten to that point. But you've raised a big important point. In all of the pretrial phase of the case, there's really this whole concept of, they used to call it risk assessment and then risk management. Those are all misnomers, right? I've already told you risk is a misnomer. We're trying to get away from even talking about supervision and control and those kind of issues, because really all we're talking about doing in the pretrial phase of the case is helping people succeed. We're slowly making progress in doing that by the way we use our words. All that is incredibly important. In fact, even though all we're focusing on these days is money bail and being kept in jail, an equally large issue is this whole era, field of non-financial conditions, of the kind of things that they can weigh you down with if you're not in jail. Those cause constitutional issues too. It's just that I happen to be mostly focused right now in my life on this one particular thing. But believe me, there's plenty of people, Andrea included, and other groups, looking at overconditioning. And by the way, if you charge money for those things and those keep you in jail, you got the same issues you do with money bail. You know, you're going to have the same constitutional issues. So it's all part of it. It's just I tend to try to scare people into the one issue. Yeah.
Try that mic. We just use this one.
I was curious, how long ago did you do the reforms in Colorado? And subsequent to that, how's the data show in terms of recidivism rates of those who were formerly kept in jail?
In Colorado, we did, we were first. That's our problem. We were first, and so we just caught a heck of a lot of opposition. All we were really trying to do is just change something in our statute. Back then, nobody ever made any sort of positive changes that were helping the bail process. Everything up until then had been bills run by the industry, and we were just constantly fighting bills to keep money out of the process. So in 2013, we did throw some things into the law, and we were hoping that it would make some really big changes. From the people, and we've made some really big changes. There are some. If you talk to certain jurisdictions, they say, yeah, now we have lawyers at first appearance. This goes back a long ways before anybody really, is doing anything. So we've still made some big changes, but the money issue still exists in Colorado. We still have it. And if anything, just by learning it, as much as we learned about money bail in Colorado, our judges didn't even know what a cash-only bond was until we started looking into bail. And now they're using it to detain people. So in some ways, we've gone a little backwards, right? It's an iterative process. Our Colorado stuff is known only simply because at the time, nobody had done anything before to make any kind of progress. And so people looked at us and said, oh, you've made some progress. Well, I look at it and think it's nothing, compared to what could be done. New Jersey has done far more. They changed their constitution, they changed everything about their laws. They created a state pretrial services agency, they created a statewide risk assessment instrument, and they've kept all their data, and their data is pretty impressive. They don't detain that many people. But we know from looking at Washington, D.C., if you want to compare to places, remember I said only one jurisdiction in America has really bought into the lessons we learned of both generations of boyfriend? Washington, D.C., a rough and tumble city, right? Crime. They release 94% of every single defendant that comes to their jail. They don't use any money at all. They simply don't use it. And out of those 94% that get released, the 6% get a really phenomenal due process hearing to stay in jail. And the other ones that get out, they come back to court 90% of the time. Every court date, stay out of trouble 90% of the time. I think it's all right. How much? We're done.
I think this works. Okay. You said that 95% of this can be done without changing the Constitution. I'm wondering what the policy levers are. Is this strictly legislation? Is it teaching? What are the levers for that 95%?
I would, not to make it simplistic, but if you educate yourself completely on this whole thing, it will become clear, but that's a very complicated issue. Theoretically, if all you started doing was deciding these are the people we're going to release, and we're going to start setting unsecured bonds or affordable bonds or whatever, you're dealing with all of the release. If you understand risk really, really well, then you're going to understand that you can release wide swaths. But it takes a lot of education and a cultural shift in our brains to do that. So the levers are many and complicated, and Terry will help you.
Thanks, Tim. I confess early that I'm not confident in my ability to wander this room in heels, so I'm going to take a seat. Just full disclosure. So good morning. It's really a delight to be here with all of you, this really impressive group of stakeholders, both in the task force and in the audience, and I'm very pleased to get to speak with you about an issue that's so very important. Before diving in, I'd like to address the elephant in the room. My name is Andrea Woods, and I work for the American Civil Liberties Union's Criminal Law Reform Project. To strip away any euphemism that might be associated with that, that means that I bring civil rights lawsuits on the part of people incarcerated on money bail requirements that they can't afford. And I also represent people who are subject to conditions of release that they're unable to afford. And I recently brought a case challenging bounty hunters and the companies that enable them to operate. So I want to be transparent about where I'm coming from. I've become immersed in these issues I'm going to share with you today because they're key to advocating for my clients. My role today is not, however, to serve as an advocate. I'm not trying to persuade you that a party's argument in a given case was better or worse. I'm here to give you an overview of what courts have said about the principles at play at the bail decision point. My goal is to be honest and transparent about where we're seeing reports coalesce and seeing a really strong statement of federal constitutional principles at the bail decision point, but also to be honest with you about where these issues are maybe more on the emerging level or where courts have come to different conclusions. And I think it's fair that you all know that. And my hope is just that this is a helpful anchoring point for the really powerful and important work that you all are tasked with and here to do. So with my time today, I plan to devote the majority of it to really digesting and talking about the core federal constitutional principles at play at the moment of the bail and release decision point. As time permits at the end, I'd like to tee up, there are some corollary issues that are related. Conditions of release has already been mentioned. I'll talk a little bit about some principles in that in my main presentation. But the majority of my time here is to really give you an overview of what the courts have said the United States Constitution requires in this space. So I'm delighted that Tim and I both picked a schoolhouse block image. That makes me feel really excited. So just to kind of zoom out for anyone who maybe hasn't studied the law formally, where we're deriving these principles. Tim has spoken to some of these already, but the framers of our Constitution bestowed a Bill of Rights. So by virtue of being human beings here on this country, we have these fundamental rights. The amendments that are most, that come into play in the decisions that I'm going to speak to you about today are the 4th, 5th, 6th, 8th, and 14th. The 5th and 14th Amendments guarantee us that we can't be deprived of liberty without due process under the law. The 8th Amendment has the excessive bail clause that Tim already covered. And then the 4th Amendment protects us from unreasonable searches and seizures, and the 6th Amendment guarantees everyone the right to a fair trial. All of those are implicated at the moment, the early moment that a presumptively innocent person's liberty is determined. And just another thing by way of context and framework, I'm going to be focusing on what federal and state court judges who've grappled with the balancing act that these amendments require us to do, what those courts have said. Tim has served this up for me very nicely, that the U.S. Supreme Court has only chimed in a handful of times. There's guidance that we can derive from some non-bail Supreme Court cases, and I'll try to point you there. But you'll hear me today talk a bit about consensus or emerging kind of decisions. That's because there's something of a patchwork, right? In a federal circuit court of appeals gives us the law in that circuit, that's helpful, but until the United States Supreme Court weighs in, it's not the law of the land. So that's part of why this is kind of couched in terms of trends and emerging consensus. So I wanted to think about, rather than kind of march through the text of every amendment or give you the facts of every given case, I thought about digesting sort of, when you review case after case over the decades, what courts are saying about the moment someone comes through the system. I would submit that you can kind of organize them in terms of 5 pretrial freedoms. I thought of FDR's 4 freedoms, good enough for FDR, it's good enough for us, right? So I'm going to offer these 5 freedoms that'll be kind of the structure of this talk. So the first key freedom we all have is the freedom from unjustified jailing of any variety, given the fundamental right to liberty enshrined in our Constitution. The second is the freedom from wealth-based incarceration specifically. I'll spend most of my time on those first 2, and there's some overlap because the act at issue is jail in both cases, but there's important distinctions I think it's useful to understand. The third freedom is the freedom from unnecessary conditions of release. We had a question kind of touching on that earlier. The fourth, the freedom to demand a fair trial. The 6th Amendment guarantees anyone accused that right. And the 5th is the freedom to be presumed innocent under the eyes of the law. So I'm going to try to take these one by one. So turning to our first freedom, the freedom from unjustified jailing, the U.S. Supreme Court has stated that freedom from bodily restraint has always been at the core of the liberty protected by the Due Process Clause from arbitrary governmental action. So I've sort of already spoken to this, but the government cannot incarcerate any of us without a very good reason. Tim mentioned the 1987 case, U.S. v. Salerno. That's where we get some of the more modern understanding of this. Salerno came about during the second wave of bail reform that Tim was discussing when federal Congress passed the 1984 Bail Reform Act. And for the first time, that act authorized preventive detention based not only on a risk of flight, but on a risk of unmitigable dangerousness to people in the community. And so there was, Tim mentioned this debate, there was genuine concern about whether that's constitutional. Can we preventatively detain people? And the Supreme Court said yes, but in saying yes, it's just how carefully crafted that federal statute is. It articulated that pretrial liberty is a fundamental right. Oh, sure. Sorry, I'll try to speak a little louder. So the Supreme Court stressed the fundamental nature of this right. I will say a couple of courts have pointed out that Salerno was dealing with the constitutionality of a statute. It didn't expressly say it was setting the constitutional floor for any pretrial decision, but there are a number of courts since Salerno to accept that the right to pretrial liberty is fundamental as articulated in Salerno. So what that means practically is that any decision to put someone in jail must be taken extremely seriously by all of us. The court, Tim kind of acknowledged this, but the court stated that liberty is the exception. Detention before trial has to be carefully, liberty is the norm, forgive me. Number one thing, scratch that. Liberty is the norm. The thumb on the scale is on the side of relief. Detention prior to trial is the carefully limited exception. So that doesn't mean that no one can ever sit in jail for trial, but it does mean that we have strong procedural protections that we need to be afforded before that happens. So the protections that the Federal Bail Reform Act of 1984 contained included what the court in Salerno described as a full-blown adversarial hearing. Public defenders were available for those who couldn't afford counsel. Notice of both the hearing itself and its purpose, an opportunity to present evidence, to cross-examine witnesses for the government, an evidentiary standard of clear and convincing evidence, meaning unless the government meets its burden to establish that a person presents a serious risk of flight or danger to others by clear and convincing evidence, detention is not appropriate. That also requires the exploration of less restrictive means to serve those government interests before jailing anyone. Under the Federal Act, judges have to state their reasons for a conditions order or detention and provide an opportunity for someone detained to appeal. So this is some of that limiting process. This is what courts since Salerno have started to kind of wrestle with. Which of these are required? But what we know is that the Supreme Court hasn't chimed in since to articulate that anything less than this would satisfy due process. So I think the fairest way to put it is this is what we know has been blessed by the Supreme Court. Lower courts have pretty consistently agreed that notice and opportunity to be heard and a statement of reasons is needed. I put an asterisk, it's a little hard to see next to counsel because I'm going to turn to counsel a little bit more in depth later.